We continue with the partial motion hearing of August 9th, 2006. The court. All right, Mr. Strang, I understand the defense has a witness. Attorney Strang. I'm going to call Stephen Glynn. The court. Very well. The clerk. Please raise your right hand. Attorney Stephen M. Glynn, called as a witness herein, having been first duly sworn, was examined and testified as follows. The clerk. Please be seated. Please state your name. Spell your last name for the record. The witness. Stephen, with a P-H, M, as in Michael, Glynn, G-L-Y-N-N. Direct examination by Attorney Strang. Mr. Glynn, what have you been doing with most of your daytime hours since 1971? Defending criminal cases in state and federal court. Do you recognize the gentleman immediately to my right? Yes, I do. Has he been a client of yours at any point? On probably 2.5 occasions. Okay, let's start with the whole occasions first. Earliest one. 1995, my firm, which was then Shallow and Glynn, was retained by the Avery family and friends of the Avery family to determine whether they were post-conviction efforts that could be brought on Stephen's behalf arising from the 1985 charge, and if I remember correctly, 1986 sentencing. We filed post-conviction motions on his behalf relating to what we call newly discovered evidence, consisting of DNA analysis conducted on material found beneath the fingerprints of the victim of a sexual assault, from which Mr. Avery had been convicted. Fingernails, not fingerprints. What did I say? Fingerprints? Yes, fingernails. Okay. This was about 1995? Yes, I think the hearing on that would have been in 1996. It was across the hall in Judge Hazelwood's court. Okay. During the period of time of that representation, was your practice exclusively the defense of criminal cases? Actually, from 1972 roughly on, if I had a total of 3 civil cases in my career to today, that would be a lot. Okay, all right. The rest have all been defense criminal cases. And the firm, of which you were a partner at the time, was almost exclusively a criminal defense firm? Yes, there was one partner who did family law. There may have been the odd, civil rights action. I mean, I had handled civil rights actions as well, but by far the vast bulk of what we did was defense of criminal cases. What was your second representation of Stephen Avery? In a civil case arising from the same conviction that was the subject of the earlier representation, and I was co-counsel on that case with Walt Kelly, who was handling the civil side of the case. I was involved to handle the criminal law related side of the case and to be a trial lawyer on it. And during what period of time were you representing Mr. Avery on that civil action? My recollection is that Mr. Avery was exonerated, and it was determined that Mr. Allen was the actual assailant in 2003. And my recollection again is that was August or September, and Walt and I were involved in the case approximately 30 days later. So let's say very early fall of 2003, up until the settlement of that case, which was sometime after Mr. Avery's charge in the present case. Were you representing Mr. Avery on that civil case as of November 5, 2005? I was, and if I may, that's the half that I made reference to. I had had some conversations with Mr. Kratz while I was, essentially, acting as Mr. Avery's criminal defense lawyer because he didn't have another criminal defense lawyer at that stage. And I was still trying to determine whether or not there was sufficient ethical conflicts between being involved simultaneously in the representation of Mr. Avery in a civil case and getting involved in the criminal case. Ultimately, that was resolved in favor of saying such a conflict existed. I talked to Mr. Kratz by telephone, told him I would not be involved on behalf on behalf of Mr. Avery very much longer at all. My recollection is that he and I then had a telephone conference with the Manitowoc County Circuit Court judge. I'm sorry, I just don't remember which judge it was at that time, because it was just a scheduling conference. It may have been even a scheduling conference on an initial appearance. I'm not sure. It was not a substantive appearance, however. And in that telephone conversation, I informed the court that I was prepared to act as Mr. Avery's counsel for purposes of scheduling, but would not be continuing to act as his counsel in the criminal case. Let me locate you in time a little bit. We have established here, and we're all clear, that November 5, 2005 was a Saturday, all right? Mr. Avery at that point was not under arrest. I think the court records and the earlier evidence here will show that he was arrested on November 9, 2005, which would have been the following Wednesday. And just to give us some time frame on the conversation with Mr. Kratz and with the judge here in this county that you have described, do you know whether those conversations were before or after November 5? I know they were after. On Saturday, November 5, 2005, and I think the period of time we're interested in is certainly the afternoon, perhaps between 2 p.m. and 5. Do you recall talking with Stephen Avery? Yes, I do. Do you recall where you were when you talked with Stephen Avery? Yes, I was in my office. Do you recall how you talked to Stephen Avery? By telephone. That would have been a wired line as opposed to a cell line in my office. That's a landline in your office? Yes, and when I say my office, I mean the law firm called Glynn, Fitzgerald & Albee, located in Milwaukee. Is the main number for that office 414-221-9600? Yes. And then you have a number of rollover telephone lines? I think at least 4 additional ones. There's 9600, 9604, 9649, and then a couple of numbers that I brought with us from the Shello, and Glynn telephones to the Glynn, Fitzgerald, and Albee telephones, which included 271-8536 and 271, I think, 9417. And then there's also a DSL line and a fax line and others. But those are the 5 telephone lines. The voice telephone lines? Yes. At least as you would call them. Were those 5 as of November 5? Correct. Do you recall whether you were dialing a cell phone number or a landline number for Mr. Avery? Can I expand on that a little bit? Sure. My recollection is a cell phone, and I need to back up a little bit to sort of set the scene, if I can. I indicated that Walt Kelly and I were representing Mr. Avery in a civil rights action based on his arrest and charging in connection with the basis for his exoneration. We were in the middle of depositions in that case and were moving from what we considered to be less important depositions to more important depositions. And this is as of November 5? Yes. And Mr. Kelly and I would frequently meet at my office on Saturday mornings to decide what we were doing next in that case and review where he had been and talk about where we were going. And November 5th was such a meeting. And we decided to have that meeting because I started another case in Door County that was set for trial on restitution, complex, white-collar crime, multi-$100,000 restitution issue, and as well as some sentencing issues. And in the course of this meeting, Walt Kelly asked me whether I had talked to a particular newspaper reporter from the Milwaukee Journal-Sentinel, and I said I had not. Walt said that he had, and the person wanted to know if either Walt or I had any comment on this strange congruence between the fact that Steve Avery is an exonerated guy who is in the middle of a civil rights action, and there is now a young woman who has disappeared who has apparently some factual intersection with him. And I told Walt I didn't have the slightest idea what this reporter was talking about. Neither did Walt. We knew nothing of a missing woman, and as a matter of fact, I think at that time we thought this was somebody from the Green Bay area. So we talked to that reporter. He told us he was running a story in the next day's newspaper, and with respect to the presentation of the Avery side of this issue, he was going to be relying on some of the statements that Mr. Avery had made to various media outlets. What day did you talk to this reporter? I'm thinking it was the same Saturday that we were in the office, and as a matter of fact, I'm sure that's when it was. And again, as a lawyer, I'm sure you can understand this, but for the record, I need to say that this was a shock, to put it lightly, because the notion that a person who had been wrongfully convicted of a crime that he didn't commit is now sufficiently trusting of the media and law enforcement that he's making statements to them boggled my mind. I mean, it made no sense to me at all. And so I said, I need to try and get in touch with Steve. And here's where my confusion is. Attorney Fallon, I'm going to interpose an objection to the narrative at this time and ask that we return to specific questions relative to the issue at hand. The Court. The objection is sustained. Question by Attorney Strang. You made the decision you wanted to call Steve, meaning Stephen Avery? Yes, that's where the confusion was as to your question. A point of confusion. Was this a cell line or was this a hard line, and did I call him one way or the other? And the answer is, I'm not real sure. I believe that I called him on his cell phone and was then requested by him or someone else who answered the phone to call back on a different cell phone that belonged either to his brother or his mother. I think I was given both numbers, so yes, I did call him back. It was on a cell phone, and I did speak to Stephen Avery. Do you recall whether there was more than one conversation that afternoon in which you actually spoke with Stephen Avery? Yes, I talked to him, 3 times during the course of what I think were 2 calls. That is, I think in one call I talked to him, and then there was an interruption. Then I talked to him again. And then the other call I just talked to him the first time. Did you talk with the law enforcement officer that afternoon too, during the course of one of the calls? I did. Do you recall who that law enforcement officer was? Only by a refreshed recollection from your showing me a report of his, whenever that was, a month or 2 ago, and frankly, a detective outside introduced himself to me as Detective O'Neill. We chatted for a little bit, and so I understand his name to be O'Neill. So if you talked to Stephen Avery 3 times during the course of 2 calls, can you place the conversation with Detective O'Neill in there somewhere for me? In that group? Yes. I believe that it was between the 2nd and 3rd, which I think were part of the same telephone call. All right. What was the thrust of your conversation with Detective O'Neill, as you recall it? What can you tell me about this matter? Is Mr. Avery under arrest? Is he a target of what you guys are doing? Do you have warrants for him? What can you tell me about this? It was basically asking him questions at the beginning. It was later telling him, after we had gone through our question and answer discussion, which was much more in the nature of questions and much less in the nature of answers, that questions by whom? Questions by me to him, and not a lot of answers being received, or at least answers that weren't terribly meaningful. That I said, well, look, I know I don't have the authority to make you stop questioning him, but I'm telling you that I don't want him questioned anymore. And I'm going to talk to him again and make sure that he tells you he doesn't want to be questioned anymore. Do you recall O'Neill saying something to you like, but Stephen is well aware he's not under arrest. He's free to leave at any time. He doesn't have to talk with us, so that's not an issue with us. Something like that, yes. What was your response to that, if you recall? He could have his view about arrest. I could have my view about arrest. The point was that I didn't want Stephen talking to him, and that Stephen would follow my advice and not talk to him. Did you then ask to speak to Stephen again? Yes. Okay. And understand, I had spoken to Stephen earlier on this same subject as well. I don't want to be volunteering stuff. Okay, and I'll try to get to it. Okay. When you took the phone, when Mr. Avery got back on the phone after O'Neill, what did he tell you? What did he tell Mr. Avery? Well, actually, I repeated something that I had said earlier, which is that I did not want him talking to the officer, that even though the officer said that he was not under arrest and at that point not a target, and that there weren't any warrants for him, that it just simply wasn't in his interest to be carrying on these conversations without the presence of a criminal defense lawyer. Not only did I want him to understand that's what I was telling him, but I also wanted him to say that to the officer. So I asked him to take the cell phone that he was speaking on, and I had the impression that he was in the house. He may not have been, he may have been on a porch of a house, and when I say house, I mean I include trailer. I don't even know what this place was that he was visiting in Crivets. But at any rate, I wanted him to take that cell phone with him so that when he made the comments to the officer, I could hear it. Did you hear him say anything to the officer? I did, and my best recollection of what I heard him say is, Attorney Fallon, objection. I don't want to talk to you. Attorney Fallon, hearsay. The court, just a sec. Excuse me? Attorney Fallon, hearsay. Self-serving hearsay by the respondent, the defendant. The court, Mr. Strang? Attorney Strang, it's not an assertion offered for its truth. It's a verbal act that was audible to Mr. Glynn. Attorney Fallon, if it's not offered for the truth, it's not relevant. The court, I'm going to sustain the objection. Question by Attorney Strang, were you able to hear any part of Mr. Avery's statements or assertion, comment of any kind to somebody other than yourself on the phone? Yes. What, in substance, did you hear? What I heard, Attorney Fallon, objection, answer, was Mr. Avery, the court. The objection is sustained. Attorney Fallon, he can ask what counsel said, that's fine. Attorney Strang, again, Your Honor, with all due respect, I think the comment here is a verbal act. Whether someone actually wants a lawyer or not, only he can know, and that's really not, the truth really isn't an issue here. What's at issue is whether an assertion that I don't want to talk to you, or I want a lawyer, or I'm going to stop this conversation, anything like that, was made in a way that was audible, both to the detective, we can infer from Mr. Glynn hearing it. The court, I think it's a statement. I think it's hearsay. I'm sustaining the objection. Attorney Fallon, I would note it is on the recording. It's already there. It's already in evidence. Question by Attorney Strang, what had been your earlier advice in the first conversation with Mr. Avery? The very first conversation I had with him was one in which I told him not to have any conversations with the officers, period. Did you ask now, going back to the time when you are on the phone with the officer, with O'Neill, did you ask him, or was there a discussion between the two of you about whether Mr. Avery was a suspect? Yes. What do you recall yourself saying to Mr. O'Neill? We have got his end of the conversation, but my recollection is that I used the word target, and that's a term I use in conversations with prosecutors. It's a conversation that I use in the relatively rare circumstances when I'm talking to a state or city law enforcement officer, and I believe that's the term I used. Would it help refresh your recollection in terms of the actual conversation or the further conversation with him if I suggested to you at some point, as I have the tape or the recording, it reflects O'Neill saying to you, for me to say he's a suspect, I haven't determined that. No. Answer, I mean, that certainly is consistent with my recollection, but that doesn't, I still may have said to him, is he a target? And he he may have responded in terms of suspect, but clearly what he communicated to me was that he was not prepared to say that Stephen Avery was a suspect, which, I construed as an outright lie. What, if anything, did you tell Mr. O'Neill about your specific role representing Stephen Avery that afternoon, at the moment that you were on the phone, alternately with the two of them? I told them that I was counsel in a pending civil case, and if this was a criminal investigation that Stephen Avery was involved in, I was acting as his lawyer in that as well. Do you recall him challenging that assertion at any time? You mean telling me I couldn't be his lawyer, or I wasn't the lawyer or something? No. Do you recall him leading you to believe that he would not respect your assertion? He would not respect your assertion that you wanted the conversation with Steve Avery to stop? I think, Attorney Palin. Objection, speculation. Question. I'm asking if you recall that. The court. Just a second. Repeat the question, please. Diane, can you read it back? Last question read back. The court. I'm going to allow it. Answer. I think that what he said was something to the effect that Steve is going to have to make up his own mind on that, or something to that effect. That caused me to say, well, look, I'm telling you, I'm his lawyer. I don't want him questioned. He certainly wasn't saying that. I don't believe you are a lawyer, or I don't believe you are his lawyer, or I don't believe that he wants to listen to you. But as a practical matter, you had to leave it at that, being on the telephone. That's right, Attorney Strang. That's all I have, thank you. The court. Mr. Fallon? Attorney Fallon. Thank you. Cross-examination by Attorney Fallon. Mr. Glynn, you have been actively engaged in the criminal defense or the defense of individuals accused of crime since 1972, correct? Actually, 71. 71. And during that time, you have had occasion to advise many individuals regarding their constitutional rights, correct? Yes. You would consider yourself relatively proficient in the scope of one's Fifth Amendment right to counsel? And sixth, I think, yes. We'll take them one at a time. Fifth Amendment right to counsel? Yes. Fifth Amendment right to remain silent? Yes. And Sixth Amendment right to counsel? Yes. Correct? Okay. Now, with respect to the events on November 5th, you were told by Detective O'Neill that Mr. Avery was not under arrest, correct? Yes. And that he was not in custody? Yes. That there were no warrants for his arrest? Yes. And then there was a question of whether I don't know about the for arrest business. I think I asked if there were any warrants, and he said no. So I don't know if I meant to encompass more than arrest. And there was a discussion regarding suspects versus targets. You think he used the word target, and he responded with the word suspect, correct? Yes. All right. And he said he is certainly not in a position to say that he's a suspect, correct? Yes, or words to that effect. Or words to that effect. All right. Now, you also indicated that you, at that time, were representing him primarily, first and foremost, on the civil rights action involving Manitowoc County, correct? If by first and foremost you mean earlier, yes. I was representing him on the civil case before I was representing him on the criminal case. And as I understand it from your testimony, you just said that you told Detective O'Neill, if this is a criminal case, I'm representing him on that too? Correct. But you had no discussion with Mr. Avery whether or not you were going to represent him on any criminal investigation, had you? No. As a matter of fact, you didn't even know if there was a criminal investigation or a missing persons complaint, correct? I believed it was a criminal investigation, and the officer was telling me it was a missing persons investigation. All right, but he told you it was a missing persons case? He did. All right. Nonetheless, without having any discussions with Mr. Avery, you were asserting that you were representing him on the criminal investigation? That's correct? Okay, now, just so we're clear, one's Fifth Amendment right to counsel does not exist unless one is in custody and subject to police interrogation, correct? Correct. One's Fifth Amendment right to counsel, Fifth Amendment right to silence, likewise, does not exist until one is in custody and subject to interrogation? Correct. And it's further, with respect to one's Fifth Amendment right to counsel, those rights are personal to the person who is the subject of the interrogation? Correct. They cannot be invoked by their lawyer. So it's been said, and similarly, with respect to one's Fifth Amendment right to silence, that is a right which is personal to one who is accused? Absolutely. That right cannot be invoked. Same as we were saying before. All right, so it's incumbent upon the individual, in person, to assert their rights on their own behalf, correct? Yes. And again, those rights don't exist if one is not in custody, correct? Well, right. If at a later hearing one is determined not to have been in custody, then those rights not being exercised is meaningless. Now, with respect to one's Sixth Amendment right to counsel, one's Sixth Amendment right to counsel does not exist until one is similarly charged with the offense for which the interrogation is to take place, correct? Today, yes. Well, it was back then as well. By then, you mean the time of the interrogation? Yes. Yes. All right. And as a matter of fact, with respect to the Sixth Amendment right to counsel, it is an offense-specific right, correct? Yes. It doesn't cover any and all cases, only the cases for which the person is charged. There is some case law that disagrees with that, but the general thrust of case law is as you stated. Attorney Strang. Your Honor, this is a field, in the sense that we have raised no Sixth Amendment claim or correlative Wisconsin constitutional claim here. It's agreed that Mr. Avery was not yet charged with a criminal offense. The formal accusatory process had not begun. The court. So it's a Fifth Amendment question, you are saying? Attorney Strang. It's a Fifth Amendment question. And again, the correlative provisions of the Wisconsin Constitution, that's right. Question by Attorney Fallon. All right. As a matter of fact, in your discussions with Detective O'Neill, as I understand your examination from defense counsel, you said, quote, I don't have authority to stop you from questioning him. You told Detective O'Neill that, correct? Right. Attorney Fallon. That's all. The court. Any redirect? Redirect examination by Attorney Strang. Question. Assuming that a person is not under arrest, and setting aside the very narrow circumstances of when it can be a crime to refuse to provide your name or your identity to a law enforcement officer, I'm talking about Hiebel, Hiibel, most recently. Setting aside that, if one is not in custody, does one in this country have a perfect right to assert a claim of silence, irrespective of custodial status, when approached by law enforcement officers? Absolutely. Attorney Strang. That's all I have. The court. All right. The witness is excused. Attorney Fallon. Pass. Thank you. The court. And hopefully Mr. O'Neill is still hovering in the hall. Mr. Strang, from my own benefit, is the motion. I don't recall if this was specified in the motion, but is your motion triggered by the portion of the interview that you questioned Mr. O'Neill on earlier, that point forward? Is there any challenge to any statements made before that point? The language about, well, I guess they don't want me to talk no more, and I got to listen to my lawyer. Is that what the defense is arguing here? Is the assertion of the right to remain silent? Attorney Strang. Yes. And I don't want to be pinned down to specific words, but We're talking about the same point in time, and it's in part 2. Attorney Fallon. It's reflected on the bottom page 4 of the remainder of page 5 from It's reflected on the bottom of page 4 and the remainder of page 5 from the report status. Attorney Strang. And I guess more importantly, the court. I think on the Attorney Strang. Part 3 and into part 4 on the Attorney Fallon. On the tape. Attorney Strang. On the tape. On the recording. The court. Right. My recollection is the part 3 ended with the officer waiting for Mr. Avery to come back after he was on the telephone. Attorney Fallon. That's correct? The court. With his attorney, and then part 4, Attorney Fallon. Picks up the court. Starts with the language that you questioned Mr. O'Neill about. Attorney Strang. Yes. Attorney Fallon. Correct. Attorney Strang. Right. We're in the right location. That's right. The court. Okay. Mr. O'Neill, you are still under oath. Mr. Strang, do you need a couple minutes to go over that? Attorney Strang. Yes. The court. All right. Let's take a short break and then we will come back for some final questions for Mr. O'Neill. Exhibit 23, marked for identification. Brief recess taken. The court. Mr. O'Neill, you're still under oath, and Mr. Strang, you may begin. Recross-examination by Attorney Strang. Is Exhibit 23 an accurate photocopy of the notes retrieved from your car? Yes, it is. If you go to the first page, the top page, the entry at the top, 14:15, is 2:15 p.m.? Yes. That's roughly when you arrived to begin talking to Steve Avery? Actually, I'm leaving the car at that point and talking to Steve and Avery. Yes. I'm sorry. I think we arrived at 2 p.m. Actually, sitting down with Stephen was at 2:15. All right. And then down at the bottom, at 5:57 p.m., which you have written in Zulu time or military time, 1757. Do you see that? Yes, I do. All right. And what you are recording there is that the property owner revoked his consent for you to be on the property? Correct. The property owner being Al or Alan Avery? Correct. What's 1055 mean? In my notations, 1055 would mean alcohol. Alcohol was a factor in that notation. Okay, but you understood the property owner to be revoking consent for law enforcement to be present on the property? Correct. If we go to page 3, you have got an entry of 15:38. Is that right? Yes. That's 3:38 in the afternoon? Correct. And you write, attorney phoned to me, right? Yes. What do you mean there? I believe that was a point where, 2 minutes before the connected phone call of Mr. Glynn, he received again a phone call, and it was his attorney, and they wanted to talk to me, but the area that we're in is really bad for cell phones, and it disconnected, and he called back, as noted in the second entry. And I can't read the time on that, can you? 15:40. So 2 minutes later? Correct. 3:40. The lawyer calls back, and the first line I can't read after 15:40. What does that say? Interview continue. Interview continued? Yes. Okay. Meaning interview with Stephen Avery continued? Correct. And at that point, Avery actually offers you the names and telephone numbers of the lawyer at some point right in there, correct? I don't believe Stephen did. I don't know if this is a notation I made when I was asking Attorney Glynn to clarify the name, and I can see that there's another name as well in the log. Right, but as a matter of refreshing your recollection, if the tape, I think the recording, has Mr. Avery saying something to you very close to, if not verbatim, quote, no, but here's his number. In case when you want to talk to me, contact them and they want to be there too. Close quote. Do you remember Mr. Avery saying? Answer. I don't remember that, but if it's on the recording, I would have to refresh my memory with that. Okay, but Do you recall Avery at least offering you a number for one or more of his lawyers? I don't remember. I don't remember if I got it from Mr. Glynn, or if I got it from Mr. Avery, or if I got it from both, or if it was the conclusion of our interview. I really don't know. Okay, but the comment here, interview continued, it's referring to the interview with Avery, not an interview with Glynn. That's correct. Okay, and then below that you have written Stephen Glynn, right? Yes. And below that you have written the name Walt Kelly? Yes. That's not a name that Mr. Glynn gave you? It may have been. I'm not certain. In fact, I didn't realize it until now that the name Walt Kelly was below my note of Steve Glynn. Okay, so whether Glynn gave it to you, or Avery gave it to you, or both, you just don't remember? I remember talking to Mr. Glynn, but noting Mr. Kelly's. Okay, and you noted the attorneys, right? I believe Mr. Kelly is an attorney, yes. Yeah, I mean, you have got a note to the right of that, attorneys. Correct. And then a telephone number? Correct. Which is 414-221-9600? Yes. Do you remember now whether you got that from Glynn, Avery, or both of them? Or do you just not remember? I don't recall. Attorney Strang. That's all I have. Thanks. And I move Exhibit 23. The Court. Any objection? Attorney Fallon. No objection to the exhibit. No questions. The Court. Okay, Exhibit 23 is and the witness is excused. The witness. Thank you, Your Honor. The Court. You're welcome. Attorney Fallon. I think that completes the evidence on this motion. The Court. On that motion, I believe it does. Attorney Strang. Yes, it does. The Court. Counsel, what are the remaining witnesses that the parties will be calling on the multiple execution search warrant issue? Attorney Fallon. The burden is still on the defense to go forward, that we have taken testimony from one of their witnesses, Lieutenant Link. So I'm not certain how many more they have and how much more we're going to do this evening. Attorney Buting. Judge, I have Detective Remaker and Sergeant Colburn, neither of which probably will be much longer than, probably be about the same length as Lieutenant Link, which was, about 45 minutes? Attorney Fallon. I think probably about an hour total. Attorney Buting. About an hour each for those. Sheriff Poggle, just briefly. And possibly Sergeant Tyson tomorrow. But I don't know that we're going to need that. And that would be it. Unless I don't think possibly Investigative Wiegert, if he had some decision-making or assigning type authority, we could find that out later. The Court. And these witnesses are all going to have something to say that's not just cumulative to what the others have said? Attorney Buting. They weren't all on the exact same searches, right? They were paired up at times, and other times they were separate with other individuals. The Court. How much time do you think is left to present the defense case with those witnesses? Attorney Buting. I would estimate about Detective Remaker perhaps a little bit longer, because he actually did more searches than anybody. Colburn, maybe a half hour. Remaker, maybe 45 minutes. The Court. What about the others? Or are they contingent witnesses? Attorney Buting. Wiegert is contingent on, he didn't do any of the searches directly, so his testimony would be only in the event he was involved in the decision-making. And similar with Poggle. And Tyson, I think there was really only a couple of searches that he was involved in, so neither one of those witnesses would be lengthy on my motion. The Court. I'm just wondering if I understand the nature of your motion and I understand the legal argument. I'm just wondering if every officer who participated in a search has to testify for you to make your point. Attorney Buting. The case law on this issue is not entirely clear, and in Wisconsin, there is none that has actually ruled on it. But the other case law I think the one thing that is pretty clear, and not surprisingly, because most Fourth Amendment law is like this, is very fact-driven. And although there's some sort of different approaches, although there are some common themes that the other courts in other states have taken on this issue. But the facts, and I anticipate the state is going to be presenting some evidence as well. The court. Well, I don't want to prevent you from fully presenting your case. I'm just questioning whether the level of detail for each witness will be necessary. What is the state looking at in terms of its witnesses? Attorney Fallon, I can tell the court that I'm looking for my checklist at the moment, but off the top of my head, I know that there will be probably 4 witnesses if I call all the witnesses they are calling. I believe we have some brief testimony from Sergeant Tyson, some testimony from Lieutenant Bowe and Lieutenant Sipple, and there will be testimony from Special Agent Thomas Fassbender. I think that's it, because I suspect that by the time defense is done presenting their case, and we'll be able to elicit testimony from some of the witnesses they are calling, that will help. Although most of my questioning for the other witnesses is unrelated to the key points that the defense is apparently trying to bring out. The court. All right, well, it looks to me like the testimony we're looking at is going to take the better part of the day tomorrow. I don't know that it pays, Attorney Fallon. I would say that's probably true. The court. To do much more tonight. We're going to have to finish tomorrow. Attorney Fallon. That's fine. The court. Regardless of how long it takes. I did have one matter I wanted to take up on the record before we leave. I think we have discussed it before. I know I've discussed it with counsel and in correspondence, and I don't believe there's been any objection to this. But in order to address some of the concerns primarily raised by the defense on the venue motion, and also under the court's own authority to keep prejudicial evidence from being made public because of the level of publicity that's attended to this case, I have ordered a number of documents sealed, and I have actually given the parties some authority on their own to submit documents under seal. A number of those documents have since been opened, but a number of them are still also sealed. And I would like to hear from the parties on the record whether they have any objection to the documents that are currently sealed or the method that the court has been using to this point. Mr. Fallon and Mr. Kratz? Attorney Kratz. Yes, Judge, we do understand that the items that remain under seal include 9 other acts motions and 1 3-part in limine motion by the state that required a probative versus prejudice analysis by the court for admissibility. We have no objection to those matters remaining under seal. It's my recollection, Judge. Perhaps I'm wrong on this, but it's my recollection that the balance of the items that originally were ordered sealed by the court have now been unsealed, and if that is, in fact, a correct recollection, we have no problem with that continuing. We do anticipate a ruling again sometime prior to trial, at least enough in advance of trial as to the other acts and that 1 3-part in limine motion. And we understand at least the court's original indication that the items that would be ruled inadmissible, the seal would be lifted, and those that the court believed, if any, would be inadmissible when remained sealed. The state has no objection to that procedure as well. The court. Mr. Strang? Attorney Strang. First, most broadly, I have no objection to the procedure the court is using on both sealing and unsealing to date. Second, more specifically, as I understand the division between which specific documents remain sealed and which do not, I have no objection there either. The proviso, I guess I would add, is that it probably would be a good time tomorrow for me to pause and just look to make sure that my understanding of what is sealed and not sealed accords with reality. The court. I have not. I know at the last hearing, before a number of documents were unsealed, I did my own inventory and attempted to make sure that anything that could be unsealed was unsealed. I have not inventoried the sealed versus unsealed documents lately, so I'm not in a position to say whether Mr. Kratz is correct as to the current state of affairs or not. However, that if I didn't mention it, the understanding is correct that once the court rules that information will be admissible, it's the court's intention at that point to unseal it. There's certainly a strong presumption in favor of openness in our court system, and it's only to maintain the integrity of the trial and protect the defendant's right to a fair trial that some of the documents have been sealed. Counsel, let's do this. I'm planning to excuse you for today, but let's plan on starting at 8:30 tomorrow to make sure we don't run into troubles as the day goes on. Anything else today? Attorney Kratz. Not from the state judge. Thank you. Attorney Strang. We had a stipulation resolving one motion. Should we make that of record tomorrow, or do we fear that we'll forget it? The court. Well, I think actually I have a list of some other things to possibly address after tomorrow's hearing, and that's one of them. So we'll do it that way, along with some of the other matters to be addressed. All right. If there's nothing further, we're adjourned for today. Proceedings concluded. To be continued.